Good day to you and welcome to another Paddocks Club video tutorial. The term duet normally suggests cooperation and harmony, but in the world of sectional title, it has a less appealing connotation. I read with interest the independent online news item on the problems in a duet scheme, that is one with only 2 units, in Valley View Road, Morningside, Durban, which problems resulted in Judge Sharon Marks appointing an administrator for 3 years. The judge said that the body corporate was non-existent, had never met, and that none of the statutory obligations had been attended to. But this was clearly not the reason that Judge Sharon Marks decided to take the responsibility for running the scheme away from the owners and put it in the hands of an administrator. There was no suggestion that the scheme was in financial distress, but clearly the relationship between the 2 owners had broken down completely. The judge is quoted as saying, "The appointment of an administrator is a drastic remedy and usually done only when there is an underlying feud between the parties." One does not know the full history, but it appears from the IOL report that whatever relationship existed between the 2 couples who occupy the sections in this scheme, Craig and Patricia Eldridge on the one side, and Shane and Jashika Manikim on the other, broke down completely when Shane was inconvenienced by having to maneuver his car around Craig's parked car. He hooted and he got out of the car, standing nose to nose with Shane and swearing at him. Things then went from bad to worse when Shane, presumably still incensed at having to drive around Craig's inconsiderately parked car, disconnected the Eldridge's water and electricity supplies, and they then called the police. The electricity was reconnected shortly thereafter, but not the water. A flurry of legal proceedings was then entered into, with claims and counterclaims flying, but what was clear to the judge was that the Manikims had unlawfully deprived the Eldridges of water for more than 3 days. The court order restrained Shane from interfering with his neighbour's water supply and appointed an administrator to run the scheme. In duets and other small sectional title schemes, and by that I mean those with less than 7 different owners, there is often in practice a total disregard for the management provisions in the Sectional Titles Act of 1986. While the body corporate exists in law, in practice the judge is right, it is non-existent, or at least non-operative. While and for so long as the owners get on with each other and they cooperate to insure the buildings and to pay the municipal utility accounts, this often doesn't cause any real problems, at least until an owner wants to sell to a buyer who needs a bond, and the bank keen to give the bond requires evidence that the scheme is being properly run. But in any event, it makes no sense to have a situation where one disgruntled owner can unilaterally turn off or switch off another's electricity or water supply for whatever reason. In smaller schemes, there should be direct supply prepayment arrangements with econometers installed in each section so that the electricity is delivered and paid for directly by the supplier and the owner of the section. Also, to the extent possible, it is sensible to have separate water supplies, or at least separate water meters on the water supplied to each section. I hope for the Eldridges and the Manikim's sake that the court-appointed administrator will do whatever he can to ensure that this type of problem doesn't reoccur after he hands the body corporate back to the owners in 3 years' time. Thank you for joining me, and if you have any experiences in this regard or comments on this video, please make them in the discussion forum.